Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is an introduction to the subject jurisprudence. You all know you are going to study the topic jurisprudence in the first semester. For the guidance of those students, I am making videos on jurisprudence. Jurisprudence is derived from the Latin word jurisprudentia. Jurisprudentia. Juris means law. Prudentia means knowledge, skill or knowledge of law. This is what is called jurisprudence. You got legal jurisprudence. The medical people, the doctors, they have got medical jurisprudence. Very famous book written by Modi. It is actually a guide for the medical jurisprudence and also for the legal fraternity also. So this is what is called jurisprudence. And please remember, the application of the skill in the law is called jurisprudence. And it is also known as legal theory. Of course, there are differences, definitely. Jurisprudence is the starting point and legal theory, jurisprudence is the genus and that is the end point. So through jurisprudence, you have developed so many legal theories. So to be precise, please remember, jurisprudence is the history behind making the law. Therefore, you have to study the history. Unless you know the history, you do not know how the act has come into existence. All of you are well aware. You know CPC, CRPC, IPC, so many acts are there. But how did they come? That is being told in the topic of jurisprudence. Please remember. So, why should you study the jurisprudence? Because, please remember, it developed the skill in law. It makes you know what is law. First of all, basically, what is law? You are sure that you know, according to Article 13, law is nothing but a bundle of rules, set of rules, bylaws, GOs, all these things. But how the law has come into existence? Second, why there is a necessity to study the law? If you know the jurisprudence, then only you will understand the necessity to study the law. And what are the sources of law? You know, Yajnavalkya Smriti, Brihaspati, Narada Smriti, the different schools of thought, that is according to Vedic period or Hindu law. But what are the sources of law? What are the thinking of the philosophers? I am going to tell you all these things. And please remember, approaches of law. Sources of law, you know, customs, religions, commerce, or habits, all these things, they are the sources of law. Different schools of thought. And later, what are the approaches of law? How you will approach the law? All these things you will be knowing by studying the jurisprudence. So, this is the basis for jurisprudence. And in this topic of jurisprudence, not only we study the different schools of thought like analytical school, sociological school, historical school, realistic school, philosophical school, economic school. Then we'll go to the theory part. Theories like utilitarian theory by Jeremy Bentham and John Savigny's Volksist theory, then pure theory of law. Yes, this. So later only the concepts will come. You have to understand the concept. Unless you make the conceptual study, it's very difficult to understand the law. Suppose take one section of law. For example, you take section 60 of the CPC, section 11 of the CPC, res judicata. So, where any matter has been directly, substantially decided by the party, and if the matter is between the same parties and the matter has been directly and substantially heard and finally decided, the court will not take up the case. Did you understand the section? Very difficult. So unless you know how to study the law, unless you know the jurisprudence, it becomes very difficult. So that is the concept. And you have to know the normative theory. Normative theory, grand norm theory, we are going to tell you. Norms, what are the norms? What is the procedural norms? So step by step. If a case is registered, if a complaint is given, they have to register a case. Then the case has to be arrested. He has to be produced to the court. Then that court has to conduct trial. Then the court has disposed the case, either conviction or acquittal. Then he has to go for a chance of appeal. So this is the normative theory. This we are going to discuss in pure theory of law. Then certain definitions you have to know. Suppose if I say he is the owner, so how do you say that he is the owner? Law says yes, the owner is held like that. But who is the owner? Who is the possessor? What is the difference between ownership and possession? So 9 by 10, possession is 9 by 10 of the ownership. This is your spread. You have to know. Likewise, what are the obligations? Definitely you have to know. Law creates rights, duties and obligations. Definitely you have to know what are the obligations. For obligations there is a separate act also. There is a contract law. Contract law totally deals with the obligations. Then ownership, possession, person. For example, if you want to define a person, how can you define? What is the concept behind the so-called person? Customs. So likewise, all these things will be discussed in this jurisprudence. So please remember, jurisprudence is the backbone of the law. Jurisprudence is the history behind the law. All of you are happy because already you have got the codified law. But before the common law in England, then what is the civil law? What is the criminal law? What is the property law? What is the personal law? All these things, they were not separate. They are all included in this common law. Therefore, you have to appreciate the common law, and as per the Article 51 of the Constitution of India, you have to foster respect to the foreign law. Unless you know all these things, it's difficult to understand the legal concepts. Then we'll go to the major cases like Maneka Gandhi case. Next, so many cases are there. Of course, when the cases come, we are discussing them. So basically, you have to know the definitions part, you have to know the schools of thought, you have to know the legal theories, then you have to go for certain part of interpretation, then you have to concept study, then normative study, then ultimately we will discuss a few important cases. So this is briefly the topics to be covered in the jurisprudence. So at the outset, I have given a brief note or introduction regarding the jurisprudence. Of course, this will take minimum 1 hour, but because of the paucity of time, because I have to tell within 8 or 9 minutes, below 10 minutes I was given time. So therefore, I am concluding here. Next we will go to the definitions part. Thank you very much.